Welcome everyone to our November Lunch and Learn webinar on Special Needs Probate 101. Today's presenters, Michele Fuller, who's the owner of Michigan Law Center and the president of Advocacy Inc., which is a nonprofit organization that administers special needs and settlement trusts. She has been practicing special needs planning for 25 years. She is the 2018 recipient of the Unsung Hero Award given by the State Bar of Michigan, and she's a published author. She will be taking questions throughout the presentation, so you can use the Q&A function on Zoom to drop your questions as they arise. And this webinar recording will be posted on our YouTube channel within like a week or so. So with that being said, Michele, you can start.
Great. Thank you so much, everybody, for joining us. And so, Maddie, if you see questions come up, if you'll just interrupt me, that would be completely fine. Just to add questions. So please feel free to do this so that it's as interactive as possible. So thank you so much. And with that, let's talk about what we're going to talk about. So this is Special Needs Probate 101. And what do I mean about that? I mean that this will be targeted toward what do we need to do for people with disabilities, or what are the things, the issues that we should be looking for our loved ones when we're involved in a probate estate. And so this could be something that even practitioners, attorneys who do general practice might be interested in as well. And so with that, feel free to talk or to issue questions, put them in the chat, and Maddie, our trusty assistant, will make sure that your questions are asked. We're going to be just doing a very brief review or overview of Michigan probate proceedings. We're going to be looking particularly at considerations and how that impacts people with disabilities, talking about the difference between first-party special needs trusts and third-party special needs trusts. And then we're going to be talking about how to plan and some top tips for planning when people have disabilities in your life. And you may be kind of on the sidelines where someone else, like a family member, has been appointed as personal representative. Or you might be the person themselves who is receiving money from an estate, and you're relying on family members or someone who's been appointed the personal representative on behalf of someone else, where you're looking for issues and concerned about your own affairs. And so if that's the case, this is the time to ask questions. And then we're going to finish up with some top tips and sprinkle top tips throughout the presentation. Probate in general is something that, in my most general description of what I do, I'm a probate and estate planning attorney. My hyper focus, my niche of my practice is focused on people with disabilities. And so we're, as we call it, special needs, whatever that means to you. It doesn't necessarily mean that someone has to have a diagnosis or receive Social Security benefits or have been determined to be disabled by a government agency to need planning. And so it just means that someone who might need some assistance, who might be vulnerable, or has maybe a condition that hasn't necessarily been diagnosed, but that they've been struggling with. And so generally, that is who we do planning for, right? And so how does Michigan probate proceedings affect people? And that's really what we're going to talk about today. And so Michigan probate is generally, we want to avoid probate, but sometimes you can't. It's not in your hands, and you must deal with the probate court. And so probate is generally divided into two aspects, two bodies of law control and impact probate proceedings. Probate, there's if somebody passes away and they have assets in their own name, where there's no beneficiary designation. It's just something that they own in their own name alone. And then there's, of course, guardianship and conservatorship proceedings for when someone is alive, but can no longer manage their own affairs. They are legally incapacitated. And then there's a whole other body of law under the Michigan Health Code that protects people that have mental health issues, and then developmental disabilities that is under that body of law. And so we'll just briefly touch on those. And so I would invite you that if you want me to take a deeper dive into any of these aspects, please email Maddie MADDIE at michiganlawcenter.com, or go to the website and fill out a contact form and just say, I'd like a deeper dive into this, or share a comment on our once it's posted on YouTube. Any one of those methods would be completely fine. And so probate in general, when people refer to probate and someone has passed away, it is the legal process to distribute assets that belong to someone who has passed away, that there is no other mechanism for distributing those funds, meaning there is no joint owner by rights of survivorship, or there is no beneficiary designation. This process, this is where a last will and testament controls. And these are the wishes of the decedent, the person who has died. And that is what the probate court oversees. So they call this person who is nominated to oversee these affairs, this distribution and process of probating assets for someone, they call that a personal representative. So you may have heard it like the executor, the executive of the estate. We don't use those terms anymore, and we haven't in a long time. But there's some misconceptions about probate where people feel if you have a will, that avoids probate. And that's not true. A last will and testament is actually the instructions to the probate court that someone leaves as to how they want their estate, their things distributed. The other thing that a probate estate does is it deals with creditors, paying debts, but mostly distributing funds according to the last will and testament. Those are the written instructions that someone has left as to what their wishes are. If they haven't left a will or a trust, then there's a default provision. The legislature has come up with what we call the laws of descent and distribution. So if someone hasn't left written instructions, then there are automatic proceedings that happen. So it's mostly, goes to the spouse and then the children, and then if there's a blended family, or if the surviving spouse is not the parent of the children, especially adult children, then what happens? They have to share on the estate. But there's default provisions, again, called the laws of intestacy or descent and distribution. Every state has them. And so if you don't want those default provisions kicking in for you, this is a great invitation or I invite you to make sure that your affairs are in order, because really nobody loves probate. Don't leave that as your legacy, which is kind of a mess to clean up. This is completely avoidable, but it does take time and attention. And so that's what probate is basically. But probate in general, when you're talking about people with disabilities who are receiving funds from a probate estate, it can have a dramatic impact on their benefits. And this is something that really needs a specialist, someone like me, or someone who does special needs planning all the time to weigh in on and work with that individual or the personal representative to make sure that whatever they're receiving as an inheritance is not going to render them ineligible for their public benefits. What can be done? Well, there's a lot of things that can be done. And it really just depends, right? The classic lawyer answer, it depends on the circumstances. But this is where somebody who has a lot of experience in special needs planning can, one, offer options, two, give some peace of mind that there are avoidable consequences. You can opt not to lose your benefits and your eligibility through some simple steps. And of course, the more money involved, the more options you have, the more planning that might be required. And so we'll go through some scenarios in a few minutes about what this looks like, what to watch for. So understanding the probate process in Michigan is, what does this look like? So someone has passed away and you have to file a set of documents, and we call them for short SCAO forms, SCAO, where it stands for State Court Administrative Office. And where does probate get opened? It's the county in which the decedent passed away. And so, or actually where they lived, not just where they passed away. So if you're living, let's say, in Wayne County and your hospital that you passed away in, or that the person passed away in, is in Oakland County, where do you open the probate estate? You open it in Wayne County. And so Every probate court has a website, and they usually have a packet, a downloadable packet of all the forms that you'll need in order to open a probate estate. I do recommend that if you are in charge of doing this, if you are the lucky person that's been nominated as personal representative, that you do secure probate assistance through an attorney. This can be a little tricky to navigate, especially making sure that things go smoothly. And so if there are sufficient monies there, you really will benefit from legal counsel. So what happens? You fill out these forms that really ask a lot of questions about the person who passed away and the people who survived them. So the heirs at law. Heirs at law are people who are your natural heirs, the people who stand to take by law from your estate. Devisees is the name that what we call people who have been nominated or who have received or to receive gifts in someone's estate through their last will and testament. And so while there might be natural heirs, let's say somebody has named all of their children as heirs of their estate as to receive funds through their last will and testament, but they've also included a godchild. That person is now a devisee. They're not an heir at law because they're not a blood relative. They're not a child, but because they've been named in the last will and testament, they're a devisee. And so all the notice requirements, and these are things that a probate attorney would know, that a person who is just having to be the personal representative to probate the estate may not realize that they have to include and send documents to that person as well. And so again, the appointment of the personal representative, that's what we call that person who is what I call the paper pusher in the probate court. So say that 10 times fast, but that's their job. And the thing is that they have an affirmative duty to act in the best interest of the heirs, of the heirs of the estate, including any devisees, over and above their own personal self-interests. And this can be a bit of a challenge for people, especially let's say that they're living in the decedent's home and have been, and now they have to move because they are, have to liquidate the house and share the proceeds with people. That is something that is frequently confronting. And again, their duty as a fiduciary, meaning that they owe a duty to others over and above their own self-interests. And so that's something that you have to take into consideration if you're serving as personal representative. And so the appointment of a personal representative means that you must follow the court rules and mandates for making sure that things are administered properly, fairly, and in the best interest of the beneficiaries. And so there's different types of probate proceedings. There's something called an informal process where there's no court supervision. You just open the estate, the personal representative administers the assets, liquidates and distributes the funds, and then it's closed. And the shortest amount of time is about 6 months from start until absolute finish. If there are matters that are where people are, let's say there's a conflict or people disagree, then you may want to go for formal administration, which means that the probate court actively supervises that administration, and the personal representative needs a court order to do any activities like liquidation, which, selling any of the assets, and certainly on distribution of the funds. And so that does increase costs dramatically, as you might imagine, as far as, for attorney fees. Like the personal representative's main charge is to distribute the funds in the estate and then close it up. So it sounds simple and easy, but it can be extremely complicated depending on what the decedent owned. Property, leaseholds, cell phone tower interests, mineral rights, companies. It can be extremely complicated. And so the more complex your assets, the more I urge you, if you don't have an estate plan, do not leave this for your family to clean up. They will not thank you later. So here's some considerations and how it impacts, probate specifically impacts people with disabilities. One is that someone may have become disabled, or and then the decedent, the person themselves, who this is their plan, um, hasn't addressed that or protected that individual in their estate planning documents. And so their last will and testament or their trust just leaves something directly to an individual, naming them directly without any protections. So if that happens, that means that person has to do their own planning. And it does impact the type of planning that we have to do, the type of trust that we are able to use. And so a direct inheritance, naming somebody individually without any protections, is risky. And it does impact their ability to remain eligible. Another way that people can do this that should be looked at would be one of the frequent things that I see is where people are named directly on a life insurance policy. Again, someone has either disabilities that hasn't been really addressed by the family, or it happened later in life and they didn't modify their beneficiary designations. And so it can be problematic for that individual when that person has passed away and now they're suddenly receiving life insurance proceeds. You see this also with 401k benefits. Why? Because it's so easy to do. You kind of you set it and forget it. And so this is an invitation. And I would say if there's a call to action here, it's really in your own planning. Go back and look and see who your beneficiaries are on your accounts, on your life insurance, and make sure that it is in alignment with your own estate plan. And so, for those who are live on this webinar, we're approaching the holiday season, and obviously nobody's going to go do that. Like, here, Merry Christmas, I've modified, my beneficiary designations. But this is a good time for the new year. Make an appointment with yourself, set aside time to make sure that you're going through this either with your financial advisor, your tax advisor, or just you looking through your stuff to make sure that your plan is in place. This is where if someone is directly receiving funds and there hasn't been any kind of mention or protection put in place to preserve public benefits or to preserve or protect that individual, this is where special needs planning comes in. This is where special needs trust can be an incredibly useful tool. We can also call them safe harbor trusts. And one of the main functions of a special needs trust is protect eligibility. And this is not a time for DIY or LegalZoom. I certainly like to recommend the least costly option for people. And for those that are interested, our next webinar is going to be in the beginning of December. That's available for registration now. And it's about using ABLE accounts to gift to people with disabilities who are on SSI or Medicaid specifically. And so we'll be going through that in detail. So if you know that you want to sign up for that, it'll be next month in time to do our holiday shopping. This is something that if you know somebody, you're either in charge of a decedent estate or you are receiving funds where you've had a family member who's passed away and you're receiving funds, this is a good time to bring in an expert. If you have disabilities and you are on public benefits of any kind, or you even have a concern, now's a great time to check into things before you receive the funds. We'll be taking a bit of a deeper dive into special needs trust and just going through basic parameters on what to expect and what you should look for. Special needs trust is the primary tool that we use as special needs planners to make sure that someone's funds are protected. And so that's what a special needs trust is. Sometimes they're called other things. They might be called, a supplemental needs trust. It might be called an amenities trust. I think one of the stranger names I've heard it called was a bubblegum trust. So attorneys who draft these can sometimes get a little too creative. I don't like doing that personally because this trust is reviewed by government agencies, including court systems, Social Security, state Medicaid agencies, and family members. And I think in the title, we need to be really careful. And it's not cute, it's not fun, but that is not a time for creativity. It should say what type of trust it is. Why? Because government agencies' names matter. But in general, special needs trusts are used to be able to shelter assets for someone with disabilities, to allow them for not just continued benefit eligibility, like SSI, Medicaid, but also to provide a system of administration outside of the probate court uh, to assist someone who may not be able to manage finances successfully on their own. And this might be for a variety of reasons. It could be because of they're very vulnerable to suggestion. They're incredibly generous. And if someone asks for money, they would give it to them. Maybe they have issues with credit card spending during different periods of time. There's all kinds of reasons why someone might benefit from this kind of administrative structure. There's two types of trusts, a first party and a third party special needs trust. And so the first question that we ask, the most important question to ask, is whose money is it? Is it the person with disabilities money, or did it come from somewhere else? And so when we talk about people being named directly as an individual on things like a life insurance policy or a 401k or a CD or even a house, does that impact their benefits? And so a home will not, unless you can only own one. So if they already own a house and someone has named them to receive a second home, then that puts them over the resource limit. And depending on their type of benefits, could make them ineligible. When you ask the question, whose money is it? If it belongs to the beneficiary, the person with disabilities themselves, that is where we need to do first party planning. And so first party means it's theirs. This comes from contract language, party, the first part, party, the third part. And first party means it's the individual's own money. And the biggest issue here is that if it is that person's own money, then a special needs trust, a first party special needs trust, means that upon the beneficiary's passing, upon their death, there's an automatic right of reimbursement by the state, by every state in which they've received Medicaid benefits. And so that's something that's avoidable with proper planning, but it's better than nothing. And the real point of that type of trust is to continue to protect eligibility for public benefits and provide a fiscal management administrative support structure. When it belongs, the money comes from someone else or anyone else, whether it's a parent, grandparent, sibling, even crowdfunding, anyone else where it doesn't belong to the beneficiary, then we can use third-party special needs trusts. And the big difference there is that there is no Medicaid payback. So what happens when the beneficiary dies? The money goes typically back to family, or it could go to charity, but typically it does go back to the family. And so this is a big deal. And you can see why if parents have loved ones with disabilities in their lives, how impactful it can be for them to do estate planning ahead of time. It's almost an imperative, because otherwise the primary beneficiary of their estate, once that loved one with disabilities passes away, is the state of Michigan. And last time I checked, there's no client that I've ever had that's something that they would want. So it's avoidable. And so this is something that families and loved ones need to be aware of. So what are the requirements of a third-party special needs trust? Remember, this is when the money comes or belonged to someone other than the beneficiary, the person with disabilities. So creating a legally sufficient third-party special needs trust is really easy. It only has these three requirements. And so you can create a legally sufficient third-party special needs trust in a couple sentences. Now, legally sufficient, is that enough? Is that okay? Is that adequate? I would say no. If I were going to give it a grade, that would be about a D. So it's passing, but it's not great. So what are these requirements? One is that the trust has to be established by anyone except the person with disabilities or their spouse. So for government benefit purposes, the government views a married couple as one unit. For benefit analysis and for tax reporting, right? When you've married filing jointly, you're one unit. So that's why a person with disabilities or their spouse cannot be the creator or grantor of these trusts. It must be funded with the funds or assets of anyone except the person with disabilities. And this means after the trust is established also, you don't want to commingle money that belongs to the beneficiary, the person with disabilities themselves, with third-party money. It's really, really important. And the other requirement is that the beneficiary cannot control the funds. So they can't own the funds and they cannot control the funds. They cannot demand distributions. And so that's it. Three simple sentences, and you've got a legally sufficient third-party special needs trust. The most important thing, again, I want to hit home is that there's no Medicaid payback required here. After the beneficiary, the person with disabilities passes away, the money goes wherever the person who created the funds, or whoever the grantor of the trust, it goes wherever this says they should go, which is really important. Also, an important distinction here is that there's no requirement that the beneficiary in this scenario be determined to be a person with disabilities. It could be when we stand these types of trusts up for people who just maybe have chronic divorces, and maybe they've had some bankruptcies in their past, so trouble controlling their own financial well-being. And people have to declare bankruptcy for many reasons. And I know that one of the number one reasons is medical debt. It depends on the circumstances, right, as to whether it would be appropriate for that person. But the person doing the planning, it's up to them and how they feel about it. So it could be a family member. Most often it is a family member or a parent who has a concern. And so it is not limited to someone who has a disability diagnosis by Social Security. So for a first party special needs trust, you can see that there's a lot more that is required. This trust is irrevocable. It can be established by the person themselves with disabilities. Here, the person must be determined to be disabled, but they don't have to be determined to be disabled by a government agency. They just have to have the diagnosis. And so we can get into like a chicken and the egg kind of controversy here, where if somebody is in the process of application or they have disabilities and they aren't working, but they just have never applied for benefits, can they create this trust? Yes. The POMS, which is the Program Operation Manual System, that is the policy, the set of policies that govern special SSI program, has determined and come out with, yes, you can establish and fund one of these types of trusts without having had a formal disability determination by Social Security or state Medicaid agency. The trust must be irrevocable, meaning that you can't change your mind and terminate it after it's established. It's irrevocable. It has to be established by the individual with disabilities themselves, their parent, grandparent, legal guardian, or a court. So you don't see a spouse in here. You don't see siblings, children. A power of attorney can do it on behalf of the individual with disabilities, but they have to have that specific authority to create a trust in that document. It must be for the sole benefit of the beneficiary themselves. They must be under the age of 65 when established and funded. And again, there's that Medicaid payback provision. So that person with disabilities dies, the trustee has an affirmative duty to reach out to all the states in which that beneficiary has received Medicaid benefits, and with the remaining assets, pay them back in the states back in their proportionate share. So here's some strategies that we use. One is that certainly avoid direct inheritance to someone with disabilities. And if this doesn't, again, it doesn't mean that the person with disabilities, so let me briefly talk about the distinction between being disabled or having disabilities and being disabled for Social Security purposes. So I'm an attorney. If I, say, lost my left foot, would I still be able to practice law? The answer is yes. So I would have disabilities where maybe I need some accommodations or special access because I would need I would want to be closer to, say, entrances or some other things. So I would have disabilities, but for Social Security purposes, meaning I'm not disabled then because I'm able to work in my chosen field. Now, for Social Security, the definition of disability doesn't mean that, if I can't be a lawyer anymore, does that mean I would meet the qualification for disability? No, I just have to be able to work and earn more than $1,550 in a month. So the bar is very low for qualification, or high, I guess, depending on your perspective. But so what we want to make sure is that when you're looking at an inheritance, do I name this person individually to receive, say, life insurance proceeds? Think carefully. It's not just about whether it would disrupt benefits, although that's certainly a top concern. The other consideration here is whether that person can manage the funds. And so successfully, right? And so if you're leaving, say, a $500,000 or $1 million policy to somebody who's really never managed that kind of money before, I think that it would be best to have some sort of administrative assistance around them so that it's not misspent or it turns into like a lottery effect. And so this is something that you want to carefully consider. But if somebody is on public benefits like Medicaid or SSI in particular, or Medicare Savings Program, or if there's any doubt, make sure that this is a consideration before you put somebody's individual name on there on a beneficiary designation form. Using a third-party special needs trust is imperative to provide that financial support and administrative structure and support around people. And also, once you do it, it is not, in other words, once you do your estate plan, it is not a set it and forget it. It is something that does need to be maintained, just like getting your oil changed on your car, getting your annual checkups, which if you haven't done that, I implore you to do that as well. But it's something that you should be doing regularly. Every time you start to prepare your finances and your, gathering information for preparing your tax return or meeting with your CPA, if you don't do them yourself, that is a great time to also review your beneficiary designations and your estate plan. And so that's just something that you should be doing on a regular basis. One of the things that we've done at Michigan Law Center is we are instituting a process for this so that it becomes just a regular routine for our clients to review their estate plans. Some attorneys call it a client care program or a client maintenance program or a family protection program. So if your attorney that you've done your estate plan with does not have that process in place, then that might be something that you want to consider, especially if you're working or considering protection for someone with disabilities in your family. And so it's really important to make sure that one of the things that we look for and are opportunities to lend additional protections. So someone may have a trust agreement. So remember that D grade, as I would say, that D grade third-party special needs trust that's created in 3 sentences that's legally sufficient, but it's not great. Well, there's opportunities even after someone has passed away to modify that trust agreement so that it can afford additional protections. And so for me, best practices, I've been doing this a long time. Best practices are a standalone third-party special needs trust, a document that is drafted for that person with disabilities, or even if you have more than one person in your family, you don't have to have a separate trust for each of those individuals. If it's your own money that you're planning for in your estate plan, you can have what's called a POP trust. Those trusts, if they are a standalone custom trust, all of the rules, all the administration, all the guidelines that the trustee follows are geared toward people with disabilities. Sometimes trusts, especially if they haven't been reviewed in a long time, the law evolves, the law changes. And as we draft, so do attorneys. The longer we practice, the better we get at it. And so the trust that we drafted, say, 10 years ago would probably not be the same trust that we draft today. And so we're always improving things. So if you haven't had your estate plan looked at in a long time, now's a great time to revisit that and make sure that the wishes are the same, or family relationships change. Trusts that have what's called HEMS standard, health, education, maintenance, and support. If that trust is designed to help someone with disabilities thrive, that is probably not the right standard, and that trust should be amended. Can we do that after someone has passed away? Chances are pretty good that we can do that. As an attorney, we'll go through some of the mandates and why we can reform defective trust. But if there's a trust within a revocable living trust, Those can be very complicated. And I think that to me is a C or a D grade third-party special needs trust. That is not best practices. Why? Because if it's a trust within someone else's revocable living trust, where are all the trust guidelines and what are all the rules of that trust administration? But they're meant to benefit the grantors of that trust by its very nature, not the person with disabilities. And so trustees, the succession planning, in other words, the roles and how things change over time and who can, what if the trustee can't do it, then who's next? All of those provisions are geared toward the grantors and protecting them. It is really not geared toward that person with disabilities. And so that's just something to look for and to look at and say, maybe we can do this a little bit better. And so there are legal avenues to take, especially in Michigan. Now, if you're reviewing this and you are not located in the state of Michigan, this is very state specific and has to do specifically with your probate or trust code as to whether you can do this in your state. Some states allow it easier than others. But this is really where a specialist has to be brought in, somebody with a deep knowledge of probate and special needs planning. Ideally, even if the trust has to be reformed, or let's say there's an improper standard like the HEM standard for someone who is on public benefits that really does not serve them well or blows up their benefit eligibility, can that be reformed? Yes. And we want to preserve that third party eligibility criteria. Why? Because again, we want to avoid that state payback, and also the criteria and the administrative rules around how third-party special needs trusts are administered are a little more flexible than on the first-party side. And so this is where probate is essential. The power of a probate court can be incredibly beneficial to the person with disabilities. So how do we go about doing this? Well, if you're in the state of Michigan and if you're a practitioner, these are the court rules. These are not the court rules. These are the statutes that allow the probate court authority to reform a defective trust. This can include, let's say, a trust that was set up and the wrong standard of distribution is in there. It calls HEMS, which is support. And the word support, anything that looks or sounds or feels like support, can be deadly for public benefit continued qualification. Again, it might be this might be worthwhile optimizing trust so that if there's a lot of assets, we pull it out of the grantor's trust, meaning mom and dad's trust typically, and we have it set up in a standalone trust that allows that revocable living trust for mom and dad to be terminated and conclude, and then it shifts over to the third party special needs trust that's dedicated to that person or people in the family with disabilities. And so there's a lot of reasons to do that. And this is the method in the state of Michigan that we can use to reform or even decant, which is kind of like, if you're a kid and you're pouring water on the sand from one bucket to another, that's what it's like. You're taking a trust that doesn't work and you're pouring the funds into a new trust that is new, improved, and optimized for that benefit, for the benefit of the individual with disabilities. That is really broad overview of probate, decedent estate probate within Michigan, and how we can really issue spot and know that there's other options for people with disabilities who are receiving funds from a decedent estate. Now, we're going to talk just very briefly about guardianships in the probate court in Michigan. We did a specific webinar on this. It's on our YouTube channel and available to review. That's a deeper dive. There are guardianship proceedings for developmentally disabled adults. And when does this kick in? Somebody who has been diagnosed with a developmental disability prior to age 22. And so this isn't someone who, is 25 and had an accident, illness, or injury that has rendered them legally incapacitated, meaning unable to manage their own affairs. And so this body of law is the mental health code, which is different. And this is specifically for people with developmental disabilities. They have to have incurred or had this developmental disability prior to age 22. Mental or physical impairment that will continue indefinitely. It results in at least 3 functional deficits or challenges, and they require specialized care. There are two types of DD guardianships. And a person who has been appointed guardian for another as a person with developmental disabilities, you'll see if you're not quite sure what type of guardianship you have, you'll see the case number will start with the year and then a 6-digit number and then a dash and a DD after that. And that tells you that you're in a DD guardianship. And so this person, whoever is the guardian, they usually have a standby also appointed at the same time. But this person, the guardian, is in charge of an individual's care, custody, and living arrangements. Basically, everything that a parent would decide for their child. And so there are two types of DD guardianships. One is called partial. This is by far the most common. It is less restrictive than the other type, which is plenary. Now, a partial guardianship automatically terminates every 5 years and has to be renewed from scratch. So a lot of people, kind of fight this, but you don't have any control over what type of guardianship the court appoints because they want the least restrictive type of guardianship available. And so the person with disabilities retains specific authority over certain aspects of their lives. It could be as simple as choosing the clothes that they wear, the activities that they do every day, the types of food that they eat, the amount of money that they're able to handle. It could be up to $5, $20, $100, that's actually a little on the high side for what I've seen the probate court typically order. But that type of authority, you can see, is very limited. And so the manner in which someone is appointed guardian is very particular, and it is far more exhaustive and protections for that person with disabilities than, say, a regular guardianship under the other body of law, which is EPIC, or Estates and Protected Individuals Code. Now, a plenary guardianship never terminates unless requested by a party. They have to file a petition to terminate. And this is for the most severely impaired people, where basically they don't retain any right to make any decision for themselves. And so you can see why the court would be very reluctant to appoint someone as guardian with that type of authority. They own this type of guardianship, guardian of the person, which can be either partial or plenary, is just over their personal affairs. Those types of decisions, where they go, who they're with, the activities, where they live, and medical treatment. The other type of guardianship is guardianship of the estate. And this is different than a conservatorship. Conservatorship is for someone who lacks capacity. It's usually due to an illness, injury, or accident, and they do not have developmental disabilities, and it happened to them after age of 18. This is where that is the distinction. And so someone who's appointed conservator manages their legal and financial affairs. Now, this could be for a minor who's receiving money. And so this is an alert in that the court rule used to be that if a minor was receiving more than $5,000, it triggered a conservatorship. Now the law has changed, where if someone is receiving more than $50,000, that triggers a conservatorship. So yes, is that a big increase? Yes, it's huge, but it also eliminates a lot of small conservatorships. And so if you are maintaining a conservatorship in Michigan, and there's, or specifically a minor or a person with disabilities or anybody that's under $50,000, the courts, I think, are still, this was a recent change. This just happened over the summer of this year, 2024. And so the courts are still kind of dealing with what to do now, because it was kind of an unexpected surprise. So if you are maintaining a conservatorship, you can, under the law, terminate that and do other types of planning for an individual. And so again, this is for somebody who is not developmentally disabled. How do you set up a conservatorship? So this could be an adult who lacks capacity, or a minor who's receiving money. And usually it's sometimes people will name a minor child on a life insurance proceeds, or typically when I get involved and I see this, it's because of the lawsuit settlement. And so these are the forms that you need in order to establish a conservatorship. One is a petition for appointment. Okay. And again, these forms are readily available, usually in a downloadable packet on your local probate court website. And again, the type of form is called a SCAO form, and it's put out by the State Court Administrative Office. And that's what they kind of call them. So you'll see that SCAO, and they're usually fillable PDFs. And so there's a petition for appointment, a notice of hearing, order of appointment, acceptance appointment, and a bond of fiduciary. And then each probate court, just to make things interesting, has their own local rules, their own supplemental forms that you will have to fill out. And so this is typically very personal information, including banking information, social security numbers, sometimes references, personal references, because the probate court wants to know who they're appointing. And most importantly, if you inappropriate some of that money, they need to know how to get a hold of you and even garnish it, your funds or your wages. They need to be able to have that power. That type of information is not made public, where any petition or hearing or order, that is all public information. Anyone can pull that file, and sometimes it is available online. Now, the probate courts have evolved so that they've stricken, and removed any kind of personal identifying information from birth, dates of birth, social security numbers. None of that is available online. So any local rules that you have to follow in order to, be appointed will ask for that information. And I assure you that is not made available. It is not public information. It is for the court's own records. So what happens? You file this petition for appointment with the probate court, and you'll get a hearing date at that time. It's usually 4 to 6 weeks out. Over the holidays, it's usually add on a couple of weeks. Or if the judge is on vacation during a period of time, you'll get maybe a little bit further out if the court is backed up. But once that hearing is set, the court will then automatically appoint what's called a guardian ad litem. A guardian ad litem is a probate attorney who's on a rotating list with the probate court to go out and be the independent eyes and ears of the court. They're reviewing the petition, what's being asked. They're independent, they're neutral. And they're seeing, does the person need a conservator? And is the person who's nominated to serve appropriate? And so they then issue a written report to the judge, either recommending what has been asked for in the petition, that person be appointed, or recommending that they not be appointed, that they're not an appropriate person. Now, here's something to keep in mind is that a person who is going to act as a conservator needs to be able to file for a surety bond. And that is basically an insurance policy for the assets in the estate. And this means you have to have good credit. And so when I ask people who are going to be appointed in this position, and I ask them how their credit is, and they go, well, then they're probably not going to be bondable. And that means, should they serve? Well, it depends. I mean, if you can't qualify for a bond, then there's another route, which is called a restricted agreement, a restricted account, which means that anytime funds are used at all, it must be through a court order, which means that you have to file a petition, you have to make a formal request to the court, attend a hearing, possible guardian ad litem appointment before you get your order, and then you take that order to the bank, and then you can get the funds. That can be an extremely expensive proposition. And so I would explore other avenues, like a trust or some other type of plan, to avoid a restricted account agreement. Now, on the DD side, they don't call it a conservator, they call it guardian of the estate, similar authority. This is somebody who has authority over legal and financial matters for someone with disabilities. This is where the mental health code applies, but it's very similar in process, where you have to file an annual accounting, you have to qualify for a bond. And so again, whether you're a conservator or guardian of the state, either way, you have to inform the court as to every penny that has come into or been paid out of an estate over the course of a calendar year. And it doesn't go, it goes according to a year from the date of appointment. And if you are interested in diving into the mechanics of how to do this, please let us know in the comments or fill out a Webflow form or get that information to us, because this is something that we're happy to do. Using an attorney or consulting with someone who is very well versed in special needs planning, probate, and estate planning, this is where you really need to be a good consumer. And if you are concerned about protecting someone with disabilities whose needs funds that are, to be managed, whether they're receiving money directly from an estate or as a result of a beneficiary designation or a lawsuit recovery, this is something that you really do need some specialized knowledge. And so choose the attorney that you work with carefully. Ask good questions. What is the extent of their experience? And it's not just years in, it's how many special needs trusts have they done? How many do they do on a weekly basis? How many on a monthly basis? Right? What is their area of expertise? And I think that reasonable minds may differ, but you need to be a good consumer here. Additional resources are also readily available on the probate court websites themselves. There are many times that people do this type of work or in front of the probate court themselves. But if you're dealing with a large amount of assets or something that's complicated, you really do need to associate with an attorney. There's also other supports that are available in your community. So I work a lot with Spring Hill Housing Corporation. There are many different types of organizations. And one of the best ones that I've also seen as to what available resources are in your community is Disability 101. And that is keeps a really good up-to-date website as to what's available in your state, no matter what state you're in, for all 50 states. There's the Special Needs Alliance. The Academy of Special Needs Planners has a consumer website as well. And there's the Disability Network is great. And so there's lots of organizations, and a skilled attorney that focuses on special needs planning should be able to bring that additional value. It's not just creating a trust agreement or going through the mechanics of walking you through the probate court. It's also helping to identify additional needs that are not being met or concerns or additional benefits that might be able to be put in place, or maybe the wrong benefits are in place, like with Social Security, and additional resources to help meet challenges. That is the real benefit of working with a special needs planning attorney, somebody who focuses on this area. And if you have any concerns for yourself or a loved one with disabilities on any kind of special needs trust administration, or you're even a professional looking for additional guidance, Administering the Michigan Special Needs Trust is available on Amazon. And this is good for both first-party special needs trusts and third-party special needs trusts. This is not a thin storybook. This is a resource guide it's over 400 pages long. And it's written in a frequently asked questions type of model. If I do this, how do I do that? How do I purchase a house? How do I go about paying for a caregiver? How do I go about buying a car? And so it also has an overview of the different types of special needs trusts that are available. And this also applies for people not even in the state of Michigan. Why? Because all the benefits that we're talking about, Social Security wise, Medicare wise, Social Security specifically, are federal in nature. And so the general guidelines on administration specifically are very similar across all 50 states. Now, there are differences. And so you can't rely on this for anyone outside of the state of Michigan 100%. But the general tenets as it impacts SSI specifically are similar across the board, across all 50 states. And so with that, I'll definitely open it up for questions, but otherwise, if you have specific questions, please feel free. But otherwise, I hope this was helpful to you. And again, feel free to subscribe to our YouTube channel. And if you have any additional requests for content, a burning question that you have, or a topic you would like us to take a deeper dive into, please let us know. Your thoughts are always welcome.
All right. I have a couple questions. Is it possible to remove a personal representative if they cannot/will not uphold their fiduciary duty?
Yes, you can. It can be expensive, but you have to bring a petition. It's usually best to do that with a lawyer. And you have to be able to show that they are breaching their fiduciary duty, meaning they are not acting in the best interest. Um, they have somehow breached what they're supposed to do, and they're not doing their job. And yes, you can absolutely do that.
Amazing. What circumstances, uh, sorry, I don't want to ask that question. What determines a court supervised versus unsupervised estate? Does having a special needs trust impact this at all?
It does not. So what will happen is that when someone opens a probate estate, they can opt to open it informal, which means no court hearing and no ongoing supervision of the probate court, or they can have formal supervision. And having a special needs trust doesn't really impact that. Um, it depends if there's conflict, really, because most estates are administered in an informal manner. But there are times where you may need a court order, even if it's an informal, decedent estate administration. For instance, if you want to modify or do something or within that estate plan to accommodate someone with special needs, then you can bring in an additional court order. So we can do that at any time. But having someone with disabilities who's receiving funds, sometimes there's what's called testamentary special needs trust, which is created by will. And do you need a supervised petition to have that happen? No. If it's in the will and it's unsupervised or informal administration, you don't have to have a special court hearing for that. It's something that's a mechanism and created by the last will and testament. So that was a really good question.
Great. Well, those are all the questions I have.
Okay.
Which is perfect timing. We can just wrap this up now. As a reminder for everyone, our next webinar is on gifting using ABLE accounts. I did leave the Zoom registration in the chat. So you can register now if you would like. And it'll also be on our website starting tomorrow. And I will send everyone a email once this video is uploaded to our YouTube channel. So you can look out for that. With that being
Thank
said,
you.
I think we're all done. Everyone have a great day. Thank you so much for joining us.
Thanks for your time, your attention. And if you have any questions, let us know. Thank you.
Bye.